Hello students, my name is Rubab and I am the lecturer for the module called IPHR, International Protection of Human Rights. The focus of today's lecture is Chapter 3, The Nature of Human Rights. A starting point and a very useful one is the Universal Declaration of 1948. In its preamble, it notes, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Article 1 then notes, all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Here it is very clear that human rights extend to all humans. They exist independently of any idiosyncrasies which any person may have, regardless of the fact that they may be a terrorist or a criminal. Rights are inalienable. We always have those rights simply because we are human. If humans are entitled to rights, what are the basic needs of a human and when should rights basically exist? Can anything become a human right, or what is a human right? What should be a human right? On what basis should we have rights? Religion, morality, a level of economic development? All of these are extreme philosophical questions which have led to much debate. To some extent, we can avoid these difficulties because certainly as far as the law is concerned, the universality, the all-encompassing nature of human rights is founded on many legal texts. Human rights treaties do not differentiate between humans. They apply to us all due to a common humanity. The debate about human rights, however, the realization of human rights basically is important if we are to have a culture of human rights. For human rights to be respected, we must have a culture in which rights are well regarded. This leads us to the first important discussion, which pertains to the legal nature of human rights, or in other words, the legality of the nature of human rights. We know that the word right can be understood in two different senses. The first one is moral, which refers to what is the right thing to do from a moral perspective. The second sense of the word refers to a relationship between right and duty or obligation which arises in the context of law. Whenever there is an obligation which arises in the context of law, we know that a right holder can compel a duty bearer to honor that right by taking them to the court. The next important factor is whenever we are trying to determine the existence of a culture of human rights, we need to see whether there is a paramount nature of human rights in a particular country. The paramount nature of human rights is either recognized by domestic law or it is not. For example, one cannot speak of legally enforceable human rights in English law as Parliament is sovereign and legally speaking could legislate against human rights. In constitutions which entrench human rights, for example, France, or make it either difficult or impossible to override such provisions, one can speak of fundamental human rights. So, the fundamental nature of human rights, their paramount nature, all of this much depends upon the attitude of the constitution, the attitude of the country, the attitude of people generically towards the legal enforceability of such rights. Returning back to the idea of the UDHR, On the 45th anniversary of the UDHR, the UN held a World Conference on Human Rights in Vienna, which is also known as the Vienna Conference, that was attended by 171 states as well as many NGOs. Now, those who wanted to drive the project forward were frustrated by the legal mechanisms available to promote and enforce human rights internationally. However, what is more important that we need to grasp from the Vienna Declaration is the debate which is most vocally now referred to as universalism versus cultural relativism. So what does it mean to say that human rights are universalism? Now, the theory of universalism comprises of three main themes. The first is that human rights exist objectively. They exist for each individual, regardless of culture, religion, ideology, etc. Now, this supports the idea that human rights are available to each one of us, regardless of the fact that we may be terrorists or we may be criminals or we may suffer from some kind of disability. What is important is that for us to be eligible to have human rights, we must be humans. So this takes us back to the initial point that we discussed, that human rights are inalienable. The second theme is that such rights pre-exist laws. So one can say that positive law merely gives them positive existence in terms of legally being enforceable. Lastly, they are inalienable. Since they exist by virtue of humanity, they cannot be taken away without endangering the same. So these were the three aspects of terming human rights to be universal. And this was a much needed proclamation after the horrific catastrophes of the Second World War. However, it was not wholeheartedly welcomed by all. Now, moving on to a deeper assessment of the Vienna Conference, what is important is that when the Universal Declaration was adopted in 1948, the global community of states was much smaller. Decolonization led to a large number of new states, which came together in 93, and a number of key themes emerged. Now, the first aspect of this emergence of debate can be regarded as a challenge to civil and political rights. Now, before we go on to discussing the two different types of themes, the two different types of aspects in terms of challenges, we need to understand that this is collectively referred to as cultural relativism. Cultural relativism is regarded as the challenge to universalism. It was promulgated by states like China, the former USSR, Malaysia, Singapore in the Vienna Conference in 1993. Now, returning back to the theory of individualism, what it basically propagates is that human rights are not universal, but they differ from person to person based on subjective contingencies, taking into account the historical, social, and cultural experiences. Now, there are two people, two academics, whose work will be taken into account. The first person is Martha Nussbaum, and she says that the institution of humans is based on two major themes. The first is equal dignity, and the second is ability to plan a life in accordance with an evaluation of one's needs. So from her work, what we can see is that she does agree to the fact that human rights are and should be based on equal dignity. However, she says that another important aspect of human rights is also the fact that people should have the ability to plan their lives according to their own needs, and their needs will obviously be different when taking into account where they live, what are their economic circumstances, which part of the world do they belong to, are they a part of a developed country, are they a part of a developing country, their gender. All of these things will play an important role when a person is evaluating their own needs. Now, it must be noted that the second aspect of the definition of human rights given by Martha Nussbaum is not catered to by universalism, which by definition excludes the inherently subjective nature of human rights by asserting that human rights are objective. The second person is Amartya Sen, and she advocates the capabilities approach. This gives that individuals should enjoy rights based on what they are actually able to do. So what this capabilities approach says is that one should provide human rights. The provision of such rights should be given by keeping in mind what people are able to do and what they are unable to do, rather than thinking of human rights as some state of utopia, as merely giving some idealistic standards upon which everybody is expected to conform, keeping in mind that the requirements, the wants, the needs of people and their ability to do something will be dependent on their backgrounds, will be dependent upon their social circumstances. Now, it is futile and rather unrealistic to impose Western values on people not taking their capabilities into account. So, for example, if we look at our country, Pakistan, the idea of not being strict on our children when we're raising them is not very common. It is commonly heard that spare the rod, spoil the child. That is how we think of an ideal kind of upbringing that we're going to give to our children. However, in a country like the USA, the idea of infliction of punishments at home which involve a physical nature or which might lead to some kind of physical distress being caused on the child may not be very feasible. Rather, it will end up in being regarded as a breach of the Convention on the Rights of the Child. So this is a single example of how practices in different parts of the world can vary, and such variance will have an impact eventually on what kinds of human rights are we talking about. Now we know that this debate about cultural relativism and universalism, even though it was given with a lot of force and vigor at the Vienna conference, it wasn't very successful. Because to the first aspect of the debate, that is saying that classical civil liberties which were luxuries, were given more importance instead of economic, social and cultural rights, to this assertion, Judge Rosalind Higgins pointed out that we have the International Bill of Rights in place. So the International Bill of Rights comprises of 3 international documents. We have the UDHR, we have the ICCPR, and we have the ICESCR. So according to Judge Higgins, she said that the provision of civil and political rights is contained within the ICCPR, and the provision of economic, social and cultural rights is contained within the ICESCR. Therefore, any kind of assertion that the international law does not seek to provide for economic, social and cultural rights is completely ill-founded. However, the existence of these two conflicting accounts of human rights does indicate that the nature of human rights as being universal is not fully accepted. Rather, it is contested. Now, having discussed in detail that what is universalism and what is cultural relativism, the examiner would ideally expect you to support your answer not just with critical analysis but also with examples. So the first example that we're going to take is of the Universal Islamic Declaration of Human Rights, referred to as the UIDHR. And the second example will be of the Cairo Declaration. Now, when you compare the UDHR to the UIDHR, we see that they differ fundamentally on three basic points. So, on one end, the UDHR talks about how human rights are enjoyed by all humans. On the other end, we see that the UIDHR speaks about how human rights are only to be available exclusively to those who practice the Islamic faith. So this immediately challenges the notion that human rights are available to everybody just because they are born as humans. Rather, according to UIDHR, human rights should only be available to those people who practice the Islamic faith. Now, this leads us to another plethora of questions, that what constitutes as the proper practice of Islamic faith? Does it mean the offering of prayers, or the giving of zakat, or the performance of hajj? All of these are capable of differing interpretations, and whether or not a person will qualify as being a devoted person practicing the Islamic faith will depend upon how every country chooses to define what constitutes as the proper practice of Islamic faith, or what is the bare minimum criteria required for a person to be eligible for asking about human rights. The second aspect is that the UDHR says that human rights are enjoyed by virtue of one's humanity. On the other hand, UIDHR says that the enjoyment of rights only begins on the performance of acts of worship obligatory on Muslims. So basically, human rights will not be available to those people who do not engage in acts of worship. The third aspect is that UDHR simply asserts the concept of human rights. On the other hand, the UIDHR speaks about rights as being divided into two sets. The first one belonging to Allah and the other one belonging to Muslims. The next example is that of the Cairo Declaration on Human Rights. Now, over here we can also see some very solid differences. The first being, the UDHR guarantees a right to choose one's own religion. On the other hand, the Cairo Declaration prohibits apostasy and outlines severe punishment. So we know that even in our country, Pakistan, there are so many examples of people who are taken into custody and are brutally treated just because they may have said something which people so claim is contrary to the religion. And they feel like it has given them the license, it has given the legal enforcers the license to take away someone's life. So these are very fundamental differences, and such differences are on the basis of religion, on the basis of Sharia law, which means that these differences cannot be set aside by a mere agreement. Now, under the UDHR, polygamy is not permitted. On the other hand, when we talk about the CDHRI, it says that the Quran permits marriage by the husband, the idea of marrying more than one woman, although this right is not available for the wife. So these are differences which again cannot be reconciled. And finally, the UDHR talks about how cruel, degrading and inhumane punishments are to be prohibited at all costs. But the Quran authorizes particularly serious punishments such as amputation of limbs and death by stoning for certain serious types of crimes. Apart from this West Islamic framework of debate, which gives clear-cut examples of universalism versus cultural relativism, we also have feminists. Now, feminists have argued that the assertion of universality basically stems from a male perspective, which induces gender discrimination and marginalizes females in human rights law. Now, this is illustrated by the fact that according to a UN report, majority of the people who live on a $1 or less a day are women. And the lack of equal opportunities for women concerning credit, land, and inheritance are all very evident. Nothing is hidden. In light of the abuses of women's rights, even though we have the International Bill of Rights, we have a specific convention dedicated to the rights of women, that is the Convention on the Elimination of Discrimination Against Women. What comes forth is that women's rights are still not adequately protected. So you cannot talk about having a universal mechanism for the protection of women's rights in place, but no kind of regional mechanisms. This then eventually feeds into the first part of the discussion, that human rights are politically, socially, economically, historically, religiously contingent and contextual. So one cannot talk about enforcing the rights of women at an international level when nothing is being done for their enforcement at the national level. And the idea that something needs to be done for their enforcement at different national levels basically gives support to our initial argument that human rights are culturally relative. There cannot be a simple, uniform kind of convention which will be successful in providing for the rights of women. Again, the fact that the nature of human rights is contested will not always lead to development. So this leads us to the next part of our lecture, which basically means that what are the consequences of the differences between cultural relativists and universalists? Should this lead to some kind of accelerated development of human rights, or will this be of no consequence? Now, in this regard, ideas of Isa Shivji are of relevance. Now, Isa Shivji said that dispute allows room for growth and development, because human rights should be seen as an ideology rather than a catalogue. Because when we look at them as a catalogue, we can see that the lists will be exhaustive. However, when we see them as an ideology, it lends support to the argument that ideologies develop with time. Ideologies are not stagnant. They cater to the differing needs of time. Now, since ideologies are constantly developing and never stagnant, there must be room for dispute, because dispute eventually leads to debate, and debate eventually leads to the growth and development of human rights, because debate leads to new ideas. A lack of consensus about the nature of human rights can be regarded as promotion of human rights. Why can this be regarded as promotion? Because if we agree about something, there has to be no debate. But if we disagree about something, there is debate. And when there is debate, there is the birth of new ideas. A primary illustration of this is the Vienna Conference of 1993, where the lack of consensus as to the universality led to the creation of ICCPR and ICESCR. However, this may not always be true. So going back to the example that I just gave you earlier, when we're talking about women's rights, we see the inadequacies of the law to protect the rights of women, but in spite of much debate, nothing has been done in recent years to come up with a new instrument which caters to the deficiencies of CEDAW. Now, to wrap up what we've done in today's lecture, we started off by focusing on what is the legal nature of human rights, and then we went on to discuss how the nature of human rights is contested post the Vienna Conference, which took place in 1993. The Vienna Conference of 1993 gave birth to what is called cultural relativism versus universalism. This debate has existed in legal scholarship for decades and is increasingly entering public discourse on international law and human rights. So universalism basically refers to the notion that human rights are universal and should apply to every human being. Cultural relativists object and argue that human rights are culturally dependent and that no moral principles can be made to apply to all cultures. They argue that principles embedded in the UDHR are the product of Western political history and therefore another form of colonization. Indeed, the origins of the Universal Declaration are rooted in political landmarks of Western history, such as the Magna Carta of the United Kingdom, the French Revolution, and the American Bill of Rights. Cultural relativists argued that universalism, in its attempt to extend a Western ideal to the rest of the world, is a form of cultural imperialism, as the establishments of the post-conflict ad hoc tribunals for Rwanda and former Yugoslavia in the 1900s and the International Criminal Court in 2002 illustrate, universalism is steadily being put into force. Cultural relativists are critical of the validity, relevance, and effect of these tribunals and of the ICC especially. Instead, cultural relativists are generally supportive of traditional or local approaches to justice, as they believe these will contribute more to post-conflict reconciliation. Having said that, once you will elaborate upon the nature of the debate of cultural relativism versus universalism, then you would have to turn to real-life examples. Real-life examples would be, for example, the debate between the Western Islamic framework. In that regard, you can give example of the UIDHR or the CDHRI. And then apart from this West Islamic framework, you can also talk about the developed and developing countries argument with reference to what feminists also have to say about cultural relativism. Finally, you would have to, in any question, you would also have to talk about what is the consequence of such a debate. So the consequence of such a debate is likely to be increase in the growth, increase in the development of human rights, and whenever you pick this stance, you can support it by the ideas of Isa Shivji. On the other hand, such conflict and debate may not always lead to any kind of development as illustrated in the domain of rights of women. So for example, we know that the CEDAW does not cater to a pertinent issue of female genital mutilation, and the CEDAW has been in place for the longest possible time. Even Pakistan is a signatory to CEDAW. However, even though there has been much debate about female genital mutilation, the CEDAW has not been modified. Neither has there been a new piece of legislation, even though talks have now started about putting in place a mechanism which prohibits female genital mutilation, but nothing has been done so far. So, debate, conflict will not always lead to development in the area of human rights. So that is all for today's lecture. In the next lecture, we will be covering questions related to chapter number 3. Thank you for watching.